And we're so pleased that you're here today to listen to this fantastic panel who's going to be talking with us about the new Massachusetts Uniform Probate Code and the Massachusetts Uniform Trust Code. I do have a few housekeeping matters to attend to, though, before we jump into our program. First, council membership. If you're not already a member of our council, we hope that you decide to join us. Our council is made up of attorneys, trust officers, investment, insurance professionals who are committed to providing quality services in the area of estate planning for the citizens of Norfolk and Plymouth counties. Of course, if somebody is from over the border, we'll accommodate them as well. The benefits of membership are educational programs such as this one today, also social opportunities to network with other professionals whom, if you're putting together a client's estate plan, you really need a strong plan, and it involves a number of different disciplines. The upcoming educational events that we are offering, January 22nd, intergenerational transfer techniques, and then April 29th, we're offering a program on ILITs, irrevocable life insurance trusts, how to design them, how to administer them. And membership forms can be obtained from Paula Friedman, our executive director, and Paula is the lady who checked you in when you came in, and if for some reason you don't pick up a form, you can always shoot me an email. I'll be glad to send you a membership form. The second item is please shut off your cell phones, and I'm probably the worst culprit on this one. I think I've shut it off and it isn't shut off, but it is very helpful if you take that extra moment and make sure that your cell phones are off. And then the third item is I'd like to express my thanks to GT Riley and Company, its personnel. They were just instrumental in handling the infrastructure items that were involved in putting together's presentation. And I'd like to express particular thanks to Paula Friedman, to Carol Major, also to Dana Boderoff, and to Harrison Ford. We have Harrison Ford, the GT Riley marketing intern. He attends, there he is, he's waving, and he is video taping today's presentation. So thank you all for your help. As you know, today's program is entitled Perspectives from the Forefront, the new MUPC and MUTC. In 2012, after about 20 years, a short period of time of deliberation, our Massachusetts legislature enacted the new Uniform Probate Code and the Uniform Trust Code. These statutory changes have made a difference in the way we counsel our clients and have also made a significant change in the types of forms and presentations that we have to provide now to the Massachusetts Probate Court. We're very fortunate today to have a distinguished panel of public officials, public servants, and seasoned practitioners who will talk with us about key features of these statutes. And I would like to introduce to you, Robert, the first person to my left is Patrick McDermott. Pat is the Register of the Norfolk Probate and Family Court. Down the line is Bob McCarthy, Register of the Plymouth Probate and Family Court. Nick Gray, who is a partner with the law firm of Rubin and Rudman in Boston. Jack Harney, First Assistant Register from Norfolk Probate. Benjamin Harley, Judicial Case Manager for the Plymouth Probate and Family Court, and then Rob Gray, who is a partner and chairman of the Trust and Estates Department for Rubin and Rudman. So for starting our program, we're going to hear from the registers of the Norfolk and Plymouth Probate, who will give us an overview of the MUPC, MUTC, and its impact on the court.
Thank you very much, Daryl. I want to commend Daryl. She's done an excellent job in putting together the seminar today. She's been very conscientious in contacting us, coordinating the event, and I know that's taken a great deal of her time. And I appreciate it. I'm relatively new on the block from the Register of Probate point of view. I got elected back in 2000, and since that time there have been many changes in the Probate and Family Court. We've been fortunate to be able to put in a new website shortly after I came on board, which I think has been a help to people. We've seen a couple of new computer systems that we've gone through. We've gone through a move to our new court in Plymouth, and we're trying to deal with the transition to the Massachusetts Uniform Probate Code and the Trust Code. And that, I think, is something that all of you are doing as well. And it was something that was talked about years and years ago, but then I think they've been there was active work on it for a couple of decades with legislative bills and so forth. It finally became law back in 2009, and it was supposed to be effective on July 1, 2011, but there was so much work involved to make the change from a couple hundred years of Massachusetts probate law into a new system that got kicked over till January 2 of 2012, and then finally March 31 of 2012 it became effective. During that period of time, there were several task forces at the Probate and Family Court to change the practices, to come out with the new forms, and to be able to address the transition. That took a lot of work, and many of the people that are here were involved in that effort. And I think they did an excellent job. As we have rolled it out, there have been issues, and there will continue to be problems in adapting to it. Staff who are used to and were trained in the old probate code have been making the transition, but it's a difficult one for them. It's difficult for lawyers, and it's obviously very difficult for the staff that's involved. But our people have done an excellent job. We're located in both Brockton and Plymouth, but our probate department is in Plymouth. So if you have a need to talk to someone or to want to see someone, Plymouth is the place to be. We accept filings in Brockton, but they are not reviewed there. They are just transported from from Brockton to Plymouth for review and processing at the Plymouth location. Probate matters, about 85% of people had lawyers. In our divorces and paternity, it's well over 50%, close to 60, of those cases are pro se. So it's interesting when people are involved. I guess they feel that they can handle their own divorce, but they know they can't handle the family estate. But now we look at it and we feel that it's about 75% of the formal and informal probates are being handled by attorneys. And then involuntaries, obviously, a vast majority of the voluntaries are being handled pro se. We find that in reviewing filings that we're probably returning about 1/3 of the filings that are submitted. If something is simple, we try and make the adjustment ourselves, but on balance we are returning about 1/3 and then to have it resubmitted. We know that that is going to be going down over time. I would say that right now it takes us maybe about 1 to 2 weeks to process an informal, and then of course if you get the formal, then you have the issues of the citation, publication, and then you're talking about 6 to 8 weeks and to have it allowed, and providing that there's no objection. In real estate, with regard to real estate, there was no changes made in the law, so the same license to sell process is in effect. And again, we're there to help you. If you have that, please get in touch with us, and we will try and address it and make sure that we get it taken care of quickly. I talked with Ben and I said, what kinds of issues are we dealing with, and we can bring out. And it was interesting because the trial court just sent something out. They're putting together a blog with regard to the 10 most 10 areas where attorneys are having some difficulty. So we have a handout here which we call Avoiding Common Errors in the MUPC. And I'll just go over it quickly. A couple of them are obvious, and one of them being proofread the pleadings. Check all relevant boxes and have all necessary signatures. And that's there because it isn't being done all of the time. The petition or voluntary statement must include all devisees in wills, including trust. Many times we find that a trust is not being indicated. It's in the will, but it's not being shown in the petition as a devisee. Provide the correct filing fees. We need those filing fees. This UPC was originally supposed to be revenue neutral, and then they discovered that it may be revenue neutral in the abstract, but when you lose all the filing fees, as was originally part of it, this is a substantial loss of revenue. So that was corrected, as you've all noted. committee went quickly to work and took care of that. The next item is the information on the death certificate must agree with that in the petition. And so the death certificate is there, and when someone's checking it, they look and they have to correlate with what's in the petition. One of them might be that, again, you need an also known as the AKA on the petition. Is there if there's a difference in the name on the death certificate and the will. And then if the residence on the death certificate differs from the domicile in the petition, an affidavit of domicile must be provided. And that happens oftentimes if someone's in a nursing home and they're in a different county and so forth. So we need that affidavit. Another item is in providing the date of death for heirs and devisees. List descendants only when the date of death precedes that of the decedent. And then if the death certificate lists cause of death as pending or homicide, you need to submit a suspicious death affidavit. And that again, the pending you see more often. The next item is that, if there's a minor heir or devotee, then there must be a formal proceeding, unless the minor has a conservator or a guardian other than the petitioner. And then if the formal filing is made, a GAL is required, but a motion to waive the GAL may be allowed with the assent of the parents. And again, that is something that comes before us with some degree of frequency. And I also would note, just as an aside, that a matter of interest that Ben had pointed out, and that is if there's a conservator who's been appointed and then there's no probate taken out, then the conservator after 40 days can petition the court to distribute protected assets. And we have seen that on some occasions. So again, I just want to note that we're here to help you. We're here at the Probate Court to provide whatever assistance we can. We know that this is sometimes a difficult matter for you to deal with, and it is also something that we want to make sure gets done in the correct way. So again, thank you. We are here to help you, and we look forward to working with you. Have a great day.
With the suspicious death affidavit, is that a form that's on the court's website, or is that something that a practitioner would simply put together?
It's on the website.
I think we have one on the website. Yeah.
There are two Bibles that we go for that when you call us up, we reference. You guys can just as easily do so. One, the MCLE source book. If you haven't gone to a seminar, I highly recommend you at least buy this. This comes usually free with one of the seminars you go to. It is a Bible of all things probate, and it's highly useful when you have a question. The second thing is kind of an in-house manual that the court developed, but I always tell, and it is available publicly on the website, and it's the MUPC Estate Administration Procedural Guide, another Bible. For anybody that hasn't downloaded this, you're late for the party. Get this, read it. It's not as laborious as the MCLE probate source book. This actually gives you hands-on what to file, when to file it, what you need to file, what priority is. It answers the 90% of your questions before you call the court. Like I said, Rick, Jack Harney, Ben Harley, Bob, we are more than willing to take the call, but please take the time to actually do your own research first. We're then happy to answer any conflicting questions that you might have. I also get to serve as president of the Registers of Probate of Massachusetts, so I represent all 14 registers. And this group of registers are extremely active in reaching out to the community and the bar on many issues, but in particular the UPC. And I think more than half of us have participated in educational seminars for the bar and the public relative to this concept. One of my jobs as the president is also to promote, and this is kind of a taboo apparently in the judiciary, but I'm pushing it, is to try to come up with some degree of conformity amongst the divisions. And I know you all are smiling. As practitioners, you're going to go to Plymouth, they're going to do it one way. You're going to come to Norfolk, and we're going to do it a different way. That has been historic over the course of time, and we're diligently trying to work with each other to come up with some best practices to promote to you folks as we go forward, so that you can have some reasonable expectations on how cases are getting processed division by division. No guarantees of a 100% uniformity, but some degree of conformity as we go forward is going to be helpful, I think, and specifically with the Uniform Probate Code. I highlight the fact that with the UPC, you are predominantly going to be dealing with the Registrar's Office, for the most part, I think, around the Commonwealth. It is very clerically driven. It's administratively driven. You will not see or need to go in front of a judge that often. In Norfolk, I would have to say, and Jack can correct me if I'm wrong, Jack is pretty much the go-to person for the allowances of all of the probates, informal and formals. But I would have to say, would we say 90% are pretty much administratively allowed? Maybe
I'd say even more than that.
even more than that. So if you have an estate, you're going to come into Norfolk, file it, and either formally or informally, obviously formally is just similar to the old way of doing things. There's citation issues, you're going to publish, you're going to get all your notice requirements done, you'll file with us, it'll eventually go to Jack's hands, and it'll be either allowed or not allowed. Informally, it's the reverse. You got to give the pre-notice requirement. It'll come in, we'll process it. It'll once again get back to Jack, and he will then either allow it or hopefully not allow it. And in fact, I don't think we've had too much occasion where we have denied an informal probate. Have we had one?
I've denied, I think, 3.
3, okay. So it's very rare. We try not to let it happen.
In those I haven't denied, I've actually just written a note. I hope you can read my handwriting.
It's awful. I apologize in advance for Jack Harney's deficiency notices.
I did flunk the Palmer method, I'll let you know.
Yes. But we part of our procedure in Norfolk, and certainly we want to make sure that we're not rejecting these. And if there is a deficiency that we can correct, we actually don't send it back. We actually keep everything. Once you've filed with us, provided it meets minimum filing requirements, like the person actually died in Norfolk County, we will accept it. We do a cursory review of the informals, but I highly recommend do not file an informal probate if you have any hesitation. Don't do it, just go formal, because unless you know definitively that this is absolutely going to be an informal, please don't file it, because it puts us in a position of rejecting it. Because if my staff takes in an informal, like I said, we're just cursory looking. We're not, it doesn't get to the magistrate right away. So once it's in the system, it's in the system. If Jack has to reject it, or if it won't go to see a judge, if Jack rejects it, you're gonna have to file a formal. And you're gonna have to go back to your client and basically explain to them why you need another $400 to file a new probate. And that's not a comfortable thing to do as a practitioner, because it doesn't put you in good light of your client. So I highly recommend on the informal process, know that what you're filing is appropriate. So in terms of that's basically the overview of the process of how we deal with it in Norfolk. We don't send things back. We will send out a deficiency notice to you. If you do have questions on Jack's handwriting, we highly recommend you call him directly. He's more than happy to take your phone call and explain what the deficiencies are. But we'll work with you to try to get it complete so that he can allow it. So this is kind of a new way of doing things in the probate court system. You won't see it. Even on the formals, you're not going to go present it in front of the judge. Even formals that are uncontested, that basically stays in the register's hand. That being said, each division, so that all of you know, each division, back when this first was being put forth, was required to appoint, between the register and the first judge, MUPC magistrates. And every division pretty much handled it a little bit differently. In Norfolk, you have myself, Jack, as well as all of the judicial case managers, who are all at least appointed as UPC magistrates. Now, Jack has been kind of a glutton on this because most of it goes to Jack, so unfortunately, the rest of the judicial case managers haven't had a lot of opportunity to digest the UPC and really work on them. So I know in Norfolk, if it's not myself, Jack, or Rick Schmidt, the assistants are a little bit less inclined to do them, only because they haven't really worked on them that much. I think we're going to change that a little bit just so that there's more people available as resources for you as you have questions. I want to highlight, I think, I know in Plymouth, you guys, the Superstars, Ben kind of handles the show pretty solidly. There is a problem in Bristol. I don't know if many people get down to Bristol right now, but there is only one magistrate that was appointed in Bristol, and that person is retiring in the next month or so. So Bristol is without a UPC magistrate for the time being. I know Register DeRossi is working, I think, to get a few appointed, but Judge Nisi failed to appoint anybody down in Bristol as UPC magistrate. So there's a mini crisis. So the solution to that, which is not good for the judge, is that they're all going to go to him. And I know he doesn't want to see all of those coming into his lobby in Bristol County. So I think that that's going to be resolved fairly shortly. That being said, we are available as a resource. We hope that once you've done your own self-education, you'll point out the flaws that you see with us so that we can try to rectify it from the court's perspective. But this is kind of a team effort amongst the divisions and certainly with the practitioners. This is all new to all of us, and we're all educating ourselves as we go forward. And I'm actually thrilled to see this crowd here today because it shows to us, at least from the court, that there are folks taking it really seriously and wanting to do the best job that you possibly can. So I appreciate the opportunity to be here. Thank you.
Pat? If a party files an informal, how long does it take for Norfolk to turn it around, assuming that everything is in proper order?
In a perfect scenario, within a week. It basically to briefly explain, from the other side of the counter, it may seem, if I get everything in shape, why can't I just walk it in, get it allowed, and walk out with my letters of authority? It is very simple, however, it is time consuming. Each informal packet has several documents that we need to, from a clerical point of view, we need to basically index the case to find out whether or not there's already a prior case on record. That takes a little bit of time to go through, and sometimes depending on the filing, there's a complicated spelling of a name, and my staff actually takes the time to run the names a couple of different ways just to make sure that we already don't have an estate open for that person. Once we've kind of indexed it, we realize it's proper for filing. It takes time to actually initiate that case. I mean, it's a clerical, you have to type in onto mass courts, the name of the petitioner, who the named fiduciary is going to be, who the decedent is, and all of the addresses, contacted. It just, from a clerical perspective, takes a little time to get that into the system. Depending on the timing of all of that, in a perfect world, it could be done within a day, because after Jack gets it done, it gets tossed back to the clerical staff for the decree and the allowance, and then the issuance of the letters. It can take, a few days to be able to do that. So I always just cautionary say it's probably about a week that it takes to get those letters done.
Okay, great.
Can we ask any questions?
Sure.
Are you just as happy, or would you rather have the informal sent, or do you like it to be brought to the counter, a quick cursory thing, and then accept it? Which would you prefer?
Sending them is fine. I mean, if anybody that actually comes into the front counter, whether it's in Norfolk or probably in any division of the probate and family court, it's a hectic hustle and bustle every given day. So that cursory analysis getting done at the front counter, if you're walking in, isn't really necessarily going to get you any leg up over the guy that mailed it in a day or two ago. We're good to process 50 to 60 new probates on any given week. So depending on staffing, it just depends on how. And we typically, if you walk it in, we're not going to basically give that priority over somebody that actually went through the burden of mailing it in. Now, that being said, too, there are emergency situations that will come up, and so if there is a specific reason why you need something done quickly, we're more than happy to make that accommodation. You know, and it may be touched on later on by Ben or Jack, but you know, the whole concept, the old concept of a temporary executor being appointed doesn't exist anymore. From an informal perspective, you can get that done fairly quickly, but if you need that immediate authority to do something, I highly recommend you walk something like that in with your formal petition with a motion to appoint an SPR, special personal representative, to do something that needs to be done in the immediate. You need to secure the assets. You need access to a safe deposit box. That's by motion practice now, but those are things that I would hesitate to mail in. Like if you need that immediate issue, that SPR appointed, that's something I would recommend that gets walked in, it gets pointed out to somebody, you know, at the front counter, preferably a UPC magistrate, either Rick, myself, or Jack, or somebody that just knows the immediacy on those particular hearings. So that's that.
Very good. Next, we're going to have Nick Gray talk to us about the UPC's substantive changes, the key highlight points.
So obviously, a lot of changes that occurred within the statute. We're going to have some fun and actually dig down into a few of the statutes this morning. I know that all of you probably brought your firearms for dealing with that problem. So there are three basic points that I'm going to cover, sort of three highlights, I think, that stand out to me anyway in the probate code that are significantly different from before. The first area I'm going to talk about is something you've heard the registrars already mention, which is there are different ways to file. You can file informally, you've heard that kicked around, you can file formally. So I'm going to talk a little bit about those two concepts more in detail. The next thing I'm going to mention is that the UPC makes some significant changes, at least in my opinion, to the intestacy statute, to the share for the surviving spouse in particular, and also to the way that per stirpes or by right of representation is calculated for descendants. So that'll be the second sort of thing that I talk about. And the third thing is a concept which takes a big meaning in the statute, which I think Mr. Harney and Mr. Harley are going to talk about later, also, which is priority of appointment. If you have many different people who have authority to serve as personal representative, who gets to win, who gets to serve? So I'm going to talk about that, because I understand that's been causing some trouble. So before we get started, though, let me just, the UPC has a section where it devotes, it defines a lot of terminology, okay? And there are five or six terms I want to get out there right now, so that would, at least for our purposes of our discussion today, the section in the code that deals with definitions, which is not in your handout, is section 1-201. So all of the section numbers that I'm going to toss out here in the course of, there are only a few, don't worry, but are related to Chapter 190B of the Mass General Laws, all of which is available online. You can get to it from that Probate Court hub, MUPC hub that's been kicked around a couple of times, which I highly recommend as well. So the first term that I want to make sure we're all on the same page about is this idea of a personal representative. Now in the old probate land, the old probate code, there were different names for the fiduciary who's in charge of running an estate. And it depended upon whether or not there was a will or no will, and whether or not you were filing to be appointed the first time or whether you were coming in as a successor. So if there was a will, generally the fiduciary would be called an executor. And if you were filing in an intestate situation, that is a situation in which the decedent left no will, you were called an administrator in general. That's all been replaced by the term personal representative. So personal representative is the generic term for the fiduciary who's in charge of the estate, and the terms executor, administrator are not used anymore. Even if they may be in the old wills, but that's not what your fiduciary is going to be called. It's going to be personal representative. So all the alphabet soup that we used to have of administrator, DBN for of the goods remaining in the estate for a person who was appointed as an administrator of an estate in a successor fashion or with the will annexed, all that stuff is history, except for case law and fun things like that. So it's just personal representative. That's the name of the fiduciary. Okay. The second term that I want to point out or highlight is the word descendant. Okay, descendant replaces or means the same thing as the word we used to use, which is issue. All right, so the word descendant is defined in the code to mean like a child, grandchild, great-grandchild, any direct descendant, no matter what degree of kindred. All right, so it's straight down from the decedent. Think of it, children, grandchildren, great-grandchildren, etc. That is descendant. Okay, and the word issue is defined to mean descendant. So that's how that works. All right, the next term I want to talk about is the word devise. Okay, devise can be a noun or it can be a verb. In its noun form, it means basically a gift and a will. So the old distinctions where a devise was limited only to real estate, and a bequest would be a gift and a will of personal property, and a legacy tended to be a gift and a will for a gift of cash. That's all been replaced by the word devise. All right, and a person who takes a gift under a will is called a devisee or a devisee. And it applies to personal property or real property. It doesn't matter. It's the same word. The next key phrase in the statute that would be useful for you to know is the word interested person. Okay, interested person is defined to be is basically a person who gets notice about who has an interest in the estate. So it might be an heir at law, which is what? A person who takes under the intestacy statute. A devisee, somebody who's named in the will. It could be spouses, children, creditors, trustees, if there's a trust that's named as a beneficiary under a will. So an interested person is an important concept to understand because a lot of things are driven off of that in the procedure. And the last term is one that was mentioned earlier, also is magistrate. A magistrate is a particular officer, a court officer, somebody who's granted authority under the MUPC to perform certain acts, such as allow these informal and formal petitions administratively. Okay? So with that said, let me drive a little bit more into detail on the difference between the various ways you can file on probate. You have an estate, you want to get it set up and running. What are the different ways? All right. If it's a very small estate consisting entirely of personal property, valued at less than $25,000, this is the probate assets now, not the non-probate assets, but the probate assets are $25,000 or less, plus the value of one car. I think we still get one car. And no real estate. If you have that situation, you can file what's called a voluntary administration or voluntary executor, voluntary probate. All right, it's usually it's a simple form, relatively simple form, maybe one page, I think. You file that, you get it allowed, and your personal representative or voluntary personal representative, whatever it's formally called, can act. Generally there's no more reporting requirements with the court. You don't have to file an inventory and account. You're in and you're out. You deal with your small estate, and that's the end of it. All right. If you have either an estate that's larger in size or has some real estate in it, then you need to file either an informal proceedings or formal proceedings. All right. The formal proceedings are akin to the system that we used before, where you file a number of documents with the court. You're asking for the will to formally be allowed, for the heirs at law to be determined formally, who's an heir, who's not an heir. There's a citation that goes out that has to be published and mailed to the interested parties before it can be allowed. Return date comes, you file your return of service. It's basically the old system that we were used to with new forms. All right? And that's, if there's any kind of trickiness or any conflict involved among the beneficiaries, or there's anything funky about the will, there's a cross out or some kind of interlineation in the will, then you need to file it formally. Now, the informal process is can be used in an estate of any size. The basic idea is you give notice to the interested persons at least 7 days before you file. Right, and gentlemen, if I get this wrong, you'll let me know. But my recollection is you send out notice to interested parties that you're going to file a petition for informal administration at least 7 days before you actually send it into the court. This is available in testate and intestate situations. And generally, once you file documents with the court, they process it. If everything's in order, they issue what was formerly called a certificate of appointment and is now called letters testamentary or letters of administration. And then the personal representative has, after he's been appointed, he has to actually then publish a notice within 30 days and send that notice, a copy of that notice out to the beneficiaries, the interested person, saying that, hey, I've been appointed informal personal representative and I'm going to start acting. So the idea is the benefit to the informal is that it generally gets you appointed faster and there's fewer reporting requirements after you've been appointed. All right? So there's no need to file with the court an inventory. There's no need to file an annual account with the court, but you do have to account to the beneficiaries. So you have this contact with the court at the beginning. You get your informal letters of administration. You go and you administer the estate. You then report to the beneficiaries of the estate and other interested persons what you did. Usually that would be sort of the account. And to sort of close it, you give the accounting to the beneficiaries and you file what's called a closing statement with the court saying, and that form is available online, saying, yes, this is what I've done and I've given the notice to the beneficiaries, and you file that closing statement, and then that's generally the end of it. All right, now if people still have time to come in, I think there's a year that has to go by before it's considered settled. But the great advantage to it is it's much less labor intensive in terms of the reporting requirements back and forth to the probate court. So that saves time and money. And it allows, if everyone's in a friendly manner, it allows the estate to be settled more quickly and efficiently. All right, so I've talked about formal proceedings. So let's look at this at the high level. Under the UPC, the surviving spouse takes the entire estate much earlier than he or she would have under the prior code. So there are two situations in which the spouse takes the entire estate. All right, that's section 2-102, subsection 1. The first reason is if there is no descendant or parent of the decedent survives the decedent. So if there are no parents, no children, or no issue, the surviving spouse takes the whole. Okay? And the second situation is in subparagraph 2. All of the decedent's surviving descendants are also descendants of the surviving spouse, and there is no other descendant of the surviving spouse who survives the decedent. This is where, in reading this part of the statute, I really wish they'd maintained the word issue, because the whole descendant-decedent thing, in addition to being a tongue twister, makes it a little harder. So I hate to, maybe I'll take a second to unpack it. All right, what it's saying is, if all of the children produce, all of the decedent's children, see, I can explain it. If all of the decedent's surviving descendants are also descendants of the surviving spouse, in other words, they share the same children, and neither one of them, spouse or decedent, has any other issue with any other person, then the surviving spouse takes the whole. Get it? So if you have in the typical traditional lucky situation, you've got a husband and a wife and 3 children, and neither of them have any other children born in or out of wedlock with anyone else, then the surviving spouse takes 100%, even though you have children of the marriage. You see that? because that's basically the I love you will, isn't it? That's what the I love you will was designed to replace. So now the intestacy statute takes care of what most people would probably want. I want my spouse to get everything. I don't, she'll take care of the kids, or he'll take care of the kids. Do you see what I mean? Yeah. Okay. So that to me, that's a big change. So if you're filing a petition for probate, informal or formal, and you have that situation, there's one heir at law, the surviving spouse. Now they may want you to list the children, but don't check the box that says they're an heir, because they're not. Right?
That's correct.
That's correct. Okay.
It's actually a little kind of a quirk in the code that even in those cases, children have to be named in the petition. It's specific in the code, even though they are not heirs.
Right.
That's the reason for naming them.
I think that's at the end, or it's been the beginning of a bunch of confusion. Both because it's because of that aspect and the fact that in the old code, children and spouse in this situation were all heirs at law. But as you can see from this statute, the spouse is the sole heir at law even if there are children, so long as all of those children are only born of those two people and neither one has anything else. Now, I'm running a little bit out of time, but the next three sections vary the share of the surviving spouse depending upon who else has a kid. All right? So basically, in either subsection 2, 3, or 4 of 2-102, your heirs at law are going to be the spouse and somebody else. Okay? If in subsection 2, if there's a descendant, if there's no descendants but there's a parent, then it's the spouse and the parent of the decedent that are the heirs. And the size is what it says there: the first 200,000 and the 3/4 of the balance, 3/4 of the balance above that. If there's subsection 3, if there's what do we have? The decedent's descendants, surviving descendants, are also descendants of the surviving spouse, and the surviving spouse has one or more descendants who are not descendants of the decedent. You see what I mean? Basically, surviving spouse has a child with someone else, a stepchild of the decedent, then you have that share. You see the idea? Okay. So that's the share for the surviving spouse. So if you have a surviving spouse, you have to go through that analysis to see what the share of the spouse is, and the balance of the estate not distributed by that section is distributed under the next section, 2-103, which is surprisingly called shares of heirs other than surviving spouse. All right, should we take a look at that?
Yeah, sure.
All right, it's on the same page, just below the same page, I think. Okay, so any part of the intestate estate not passing to the decedent's surviving spouse under section 2-102, or the entire estate, if there is no spouse, passes in the following order to the individuals designated below who survived the decedent. Now, what I want to point out is the sequence of who inherits is fairly similar to the old statute, but the way that the new concept here is this per capita at each generation. All right, so let's look at it. Who's first in line if there's no spouse, or to the share of the estate not given to the spouse? First person are the descendants. Per capita in each generation. Put a note on what that means. That's defined in section 2-106, which is in your handout. I'm going to talk about it in a second. But basically, if the share not distributed to the spouse goes first down the family tree to descendants. All right? If you have no descendants, then it passes back up the family tree to the parents, if the parents are alive. Either depending on who's alive. Equally if they're both alive, or all to one. All to the survivor. If you have, then, subsection 3, if you have no descendant and no parent, then it's going to, here's a trick. Ready? To the descendants of the decedent's parents, or either of them, per capita at each generation. What the heck does that mean? Descendants of the decedent's parents. What are we talking about here? Siblings. It's basically siblings and issue of deceased siblings, otherwise known as nieces and nephews, I think. Right? Okay. So when you get home tonight, practice in front of the mirror. Descendants of the decedent's parents, or either of them per capita. Basically, it's just you go back up to the parents and you look at their descendants, and you figure out using what per capita at each generation. Basically, if in the case, for example, where there's a decedent and he's dead, all he's survived by are 3 siblings. The 3 siblings are going to share it equally. If there's a deceased sibling who left surviving descendants, those descendants will step up. The trick gets to be what happens when there's more than one deceased sibling and each of them left an unequal number of children. That's where the per capita at each generation comes into.
There's also an heirs chart. It's not in your, I don't think it made it to your packets, because I don't think I emailed it over, and I apologize for that, but it's very easily found at the hub. It's called an heirs chart, and it's what the trial court developed, and we go to it every day to just make sure. It's I think it's a fairly simple approach as to who is the heir. You know, obviously, if you're getting into deep problems with great aunts and uncles and third cousins twice removed, you're more professional than I am. But that heirs chart is pretty good for those simple estates, just to take a look at.
Nick, in your practice, when you get through talking with the client, what would you like in your will? Per stirpes or per capita? Have they given you any feedback as to what?
I know that the advocates for the Uniform Probate Code said that most people prefer this per capita at equal generation.
Fairer.
But my experience is no. They want their children's family branches to each get an equal share. Now, that's the way I find it. So that's another reason why you have to draft a will, is to undo that if you don't like it. I don't know. It depends, but usually I find people wanting the family branches to be equal rather than the that would be
Grandkids.
Yeah.
Very good. We're going to move on to hear from Jack Harney and Ben Harley to talk to us about the procedural changes from the UPC and MUTC.
Good morning. In your materials, you have a checklist for filing both formal and informal proceedings. I'm not going to go over them because they're self-explanatory, but I do urge you when you start filling out your pleadings to refer to them to make sure you don't miss anything. Many of the common errors I see are on bonds. The section where it says to accept appointment as, and there's a blank line, it's left blank. You should be putting in there personal representative, special, SPR, special personal representative, or whatever type of fiduciary it is. The other thing I would urge you to do is, when mailing the materials in, pay attention to the bond. It has 2 pages. Quite often, we're not getting the second page. Now, when a bond is without sureties, you think, well, why do I need the second page? Well, if you don't give me the second page, I don't have anything to sign. So it does make it easier if you do that for me. Let's see. So we got that. One of the issues people often ask, should I file formal or informal? Well, it's a loaded question. It's very, very dependent on the circumstances. A couple of rules of thumb. If you have a case where you have minor children who do not have court-appointed guardians or conservators, then you must file formal. You cannot file informal. The same is true if any of the interested parties are under a disability, in which case we will need a guardian or conservator. If we don't have that, you must file formal, and there's just no way around it. Now, as I said earlier, I've only actually declined 3 cases. Well, that's not quite true. Often when I get a case which is an informal and it's defective, I'll write a note back indicating that they should file a formal because they cannot file an informal, which will mean, of course, another filing fee, and I'll just let the formal supersede the informal. Another issue on that is when it comes to the appointments. When we first started, I was under the theory that the best way to approach the MUPC was probably to file informally and close the estate formally. The more I look at it, the more I think of it, I'm now coming around the other way. In many respects, you should probably just as easy to file formally, as there are some advantages to it. It gives you fewer opportunities to make mistakes. Now, when you file an informal, as was mentioned earlier, it can generally be allowed in a week or 2. So if you're in a hurry to get an appointment, because you want to sell some real estate and you just want the appointment quickly, sure, go with an informal. One of the requirements that was mentioned, you must do a post-appointment publication. Now, the court does not look for a return of service on that. But if you are going to seek under an informal a license to sell real estate, then I'm going to be looking for that publication. Because if you don't produce that for me, I've got to issue a citation on the license to sell, even if you have all the assents, because it will be the notice to the creditors. Another issue on that is, technically speaking, if you forget to do the publication, that will be grounds for a creditor to seek a removal. And in the case where there's a statute of limitations, it might give them an opportunity to seek an extension of time. So from that point of view, sometimes you're better off doing a formal, because under the formal, it's very akin to the old system, where the court issues a citation, and you don't have to worry about whether or not you've met all the requirements. Now, one of the new concepts also is the court can now, you can now determine heirs. Under the old system, we really didn't determine heirs in the sense that we just listed who they were, but they weren't really determined. Under this system, you can do that, and when it comes to title, if you're going to sell the real estate, I don't think it's necessary to determine the heirs, because within the year of the appointment, the property is gone anyway, so technically, title rested in the estate. But if you're going to keep the real estate, I have a couple of recommendations. I am not a title expert, but since now we can determine heirs, is my understanding, a lot of title companies want that to be determined. So how can we do it? There is a way of doing it, obviously under a formal, but also an informal. And I recommend doing a formal if you're going to, if the intent of the parties is not to sell the real estate, just because it's easier. But under an informal, you file the petition as one normally would. You then, in closing the estate, instead of just doing a closing statement, you would file your inventory, your final account, and file a petition for complete settlement. As part of that petition for complete settlement, the court, you can ask the court to determine the heirs. Even though you may have all the assents of all the interested parties, because you're determining the heirs, the court must issue a citation. Under a formal, the court is issuing a citation anyway up front when you file the pleadings. As part of your request in the formal, you can ask that the court determine the heirs. So that is already done, and presumably that will satisfy a title company when it comes to future sales down the line. One of the other things that tends to come up on a lot of these is going back to minor children. It does say that you may file an informal if we have a guardian or a conservator. In the case where the heirs are minor children, what do you do? Well, first of all, to file an informal or a formal, we need a guardian or a conservator. A guardian may file, but a guardian may not be appointed a personal representative. A conservator may file, and the conservator may be appointed a personal representative. So in those particular cases, I would recommend getting a conservator appointed for each of the children, if there's more than one. And a lot of parents think that, well, I'm the parent, so therefore I'm the guardian. They are not. They are just the parents. And they do not have standing on their own to file on behalf of children. Now, there is theories of parental representation and the like, in which case when you have filed a formal and you bring a motion to waive a guardian ad litem, often you go before the court with such a motion asking that, and your argument will be, well, they're being represented by the parents, and more often than not, a court will go along that, but it's not automatic. So your options when you have minor children who are not represented, one filing a form asking the court to either appoint a guardian ad litem or a motion to waive the appointment of a guardian ad litem with a suitable affidavit.
Okay, well, let's move on to Ben and your treatment of the UTC.
I'll stand up.
Very good.
I'm chained to my desk most of the day, so it's nice to have a chance to stand up for a change. Now, we're really going to have to switch gears here because we're now moving into the Uniform Trust Code, and there's very little connection to the Probate Code. I think we'll see as we go along here. Recently, an attorney described the Probate Code to me as a great solution to a problem that didn't exist. So I immediately, in my mind, agreed and extended that to the Trust Code as well. Now, I'm sure there is a benefit to somebody somewhere in all these changes in the law, but it's certainly not the court staff. We have been overwhelmed for the last several years with this code, with both these codes. Not only have we had to learn it while we're still involved in our own duties through the day, but we're now in a position that we find ourselves constantly having to educate the public, the bar, and the court staff with all these new changes. And believe me, it's almost overwhelming. I mean, Jack and I go back, we decided this morning, I think combined, we have 72 years in the probate court system, and this is the worst we've ever seen it, really, at this point in time. So all we can do is onward and upward, and we do the best we can, and we just ask for everyone's patience as we go through the day. Now, there's a reason that the name Massachusetts shows up in the Uniform Trust Code, title, and the Probate Code. And that is because we put our own little twist on it. Now, some people suggest we're smarter than everyone else. I don't know, but these codes are not the so-called pure codes. They are the Massachusetts version of the Uniform Trust Code and the Uniform Probate Code. And we'll see some of that as we go through here. Now, the Trust Code itself is found in the new General Laws, Chapter 203E. Historically, much of our statutory trust law was in Chapter 203. Now, much of 203 has been repealed and replaced by 203E, but not all of it. Just to make it a little more interesting, there's still a few sections left in 203 that you have to be mindful of. Some of them have to do with real estate issues, things like you can't have oral trusts when there's real estate involved. You can consult those sections. Now, we've talked a little bit about information available on the court website, and I would like to stress that I have a very short amount of time here, and this is an enormous subject. So there is a Mass Uniform Trust Code procedural advisory. If anyone's familiar with it, I'm not sure, but I have a copy. I have it with me here. I keep it right by my phone all day long, and it's available on the court website. The easiest way I find to get on this is just go to mass.gov, and once you're in there, you'll see links to the judiciary and the court system, and just keep following those links into the probate court, and that's a way to find all the probate information that's posted online. So the procedural advisory on the trust code, it's about 24 pages. I mean, I strongly recommend you go back today, find it and print it out and keep it handy. It's an excellent resource. And in addition to that online is what's referred to as the report of the Ad Hoc Mass Uniform Trust Code Committee. Now this is, it's a little longer. It's essentially a summary, or more than a summary, it's essentially the code itself with reporter's notes from the Uniform Trust Code Committee reporters at the end of each section to help explain and clarify what the various sections mean. I think that might be 40, 50 odd pages, but definitely you want to print that out, have it available. So between the copy of the procedural advisory that I have here and that ad hoc report, you'd be really set up. You'd have everything in front of you and you could go forward from there. Now, the trust code itself is divided into a number of articles, and it specifies that it applies to both testamentary and inter vivos trusts. Now, in the past, we didn't have a lot of statutory reference on inter vivos trusts. Chapter 203 dealt mostly with the testamentary trusts, those that are created in a will. And so now we have to keep in mind that the code covers both these situations. A lot of the inter vivos trust issues that came up historically were handled on the equity side of the probate court. Now, our court, probate court, has so-called equity jurisdiction. It's conferred by statute in Chapter 215, Section 6. And again, just to make things interesting, that was not repealed. So now we have a situation, more or less concurrent jurisdiction of a lot of these trust issues, both on the equity section in Chapter 215 and in the new Chapter 203E. So what are you supposed to do? Now, there's a good argument that's been made that any remedy on the equity side of our court should only be available if there is no statute that gives relief. And in the past, to matters dealing with particularly inter vivos trusts, there was no statute. So it was our equity jurisdiction that allowed the probate court to hear matters relating to trusts. Now, the argument has been presented that if a matter is filed under that equity jurisdiction today, that it is subject to dismissal for lack of jurisdiction if there is a remedy under the trust code. So you have to be very careful, whatever issue that may arise, to make sure that it's not covered by the trust code, because if you come into court and try to file something in equity relating to that trust, you well could find that that equity matter would be dismissed for lack of jurisdiction because there is a remedy now under the trust code. So it's technical, and it's complicated, and I don't know of any other way to approach it, but just to keep that in mind. Now, as I said, the code is divided into several articles, which brings up something else to be cautious about. In the Massachusetts Probate Code, Article 7 deals with trusts. Now, Article 7 of the Probate Code was repealed before it was effective by the Trust Code. And again, to make it more complicated, I reviewed a new complaint in equity that was filed 2 days ago in Plymouth. Very large Boston law firm. You would think that they would all know better. They cited as a basis for their jurisdiction Article 7 of the Probate Code. It's repealed. And it's interesting, it was effective, but never actually implemented, because the Probate Code was, the effective date of it was extended beyond the original implementation date to give the court staff a chance to try to learn it a little better. So you just don't fall into that trap that Article 7 of the Probate Code, it says trusts, we've got the Probate Code all here. It's, except for one minor section of Article 7, it's all been repealed. So you want to make sure you don't, if you pick up a copy of the Probate Code, you're going to see Article 7 in there. And you may think, gee, this has to do with trust. Well, it did, and now it doesn't. So that's been repealed and replaced by by Chapter 203. Now, I know I don't have a lot of time, but I'm here to talk about procedure. Attorney Rob Gray is going to talk about more of the substance of the new code. So procedure involves three basic things with the probate court. We have the Mass Rules of Civil Procedure. They're going to apply. We have the supplemental rules of the probate court. They're available in all the rules books. We have forms, and we have fees. And everything has to be right, otherwise you have a problem. You can have the best case in the world on the facts, but if you can't get it filed, it's not going to do you much good. So the forms themselves are available again online. There's a MUPC forms page on which is located all the trust forms. So you'll find that, as Pat mentioned, I guess you could just Google MUPC, that'll come up. You want to go to the forms page, and you'll see all the new trust forms there. They're very good forms. They're tailored to match the sections of the code. They're fillable online, and there's a lot of new law that's involved here. One example, the one you see most commonly, is to do with testamentary trusts. Now, in the past, if you had a will allowed and the will contained a trust, you needed to file a petition with the court to have that trustee appointed. That's no longer the case. The idea behind the trust code now is that once the will's allowed, the trust is created as part of the allowance of the will. But what you need to do now is to confirm the appointment of that trustee in that will. And you do that by using the new form we have. It's called Statement of Confirmation of a Testamentary Trustee. There's no fee, but it does require a bond. Now, this is the only type of trustee that is required to post a bond now. I'm sure you'll hear from Rob shortly that in so-called inter vivos trusts now, there is no longer a bond requirement. Now, the bond has a filing fee, that's $75, and we generally advise people you need an attested copy of that statement of confirmation as evidence of the appointment of the trustee. That's another $5. So it'd be an $80 fee submitted, the statement of confirmation, and the bond of trustee. Now, we've had a lot of issues relating to the bonds, to the dates of appointment, effective dates, and accounting requirements. The way this is being approached is that any appointment of a trustee prior to the effective date of the trust code carries with it the so-called old form of bond. Now, that bond is the one that has the accounting requirement built into it, and those trustees are still required to file accounts with the court. Now, there is a provision in the probate code that also applies to the trust code that allows a trustee to come into the court with a petition to modify that old bond. And we thought that we'd be buried with these things, and interestingly, we've seen very, very few, but the idea behind that is that a trustee could theoretically file this petition to modify their old bond, have it replaced with one of the new probate code bonds on which there is no longer an accounting requirement. So we thought we'd see a lot of these, that a lot of trustees would be interested in getting off that responsibility of filing annual accounts with the court, but we haven't seen them. So maybe after today, we'll see a lot more now that I put that out. But it's just one of those interesting concepts that never seem to have caught on. And again, those are forms that are available online. The accounts themselves that are still required to be filed can no longer be allowed just on request of the trustee. The code now requires petitions to allow accounts. So you've got an additional layer of pleadings and filing fees to be mindful of. It used to be if people wanted accounts allowed, they just send them in with a letter requesting a citation, and we'd issue one, and the accounts would be processed. Now you need a petition. And in the case of a trustee, it's a petition for allowance of account, which I don't think is available on the trustee forms page. You have to go to the probate code page and look for that form. But there are specific trust accounts available online as forms, and there still is a requirement that trustees have to develop accounts for their beneficiaries, but the requirement is no longer do they need to be filed with the court on the new appointments. The bonds themselves for the testamentary trustees are the same as the probate court bonds, and there's a reference to that in the trust code back to the probate code. Any pleading that needs to be filed under the trust code is now by petition, it's not by complaint. As I say, historically, many of these matters relating to trust were in equity. They were required to file complaints under the civil rules, but now it's all by petition, and we issue citations, and be mindful of all the filing fees on the petitions. If this is a new case in the court and there's been no prior filings, there'll be a surcharge. There's a fee for the citation itself, $15 for all citations. And the trust code is going to direct you back to the probate code under section 1401 for the manner of service of your petition. So there is some interconnection between the two codes. Yeah.
About 2 minutes.
I have about 2 minutes? Okay. Any questions before I sit down? Everybody must be confused as I am. We have a lot of issues with GALs now under the trust code. And again, there's some of these same ideas of virtual representation and parental representation that were mentioned in the probate code. If there is any ambiguity or any confusion in the filings, if the judicial case manager sees that there could be an issue of a minor and isn't satisfied that there's some parental assent filed with that minor's or on behalf of that minor, that GAL is going to be required. You always have the option of filing a motion and coming in before the court to waive the GAL based on the parental assent, for example, of a minor, but the burden will be on you, not on the case manager, to carry that for you. And just one other aside, we mentioned about the MUPC magistrates now who are able to allow informal and formal proceedings in probate. None of that applies on the trust code. It's been determined that the probate magistrates have no authority on matters dealing with trust. So everything dealing with a trust is going to go to a judge. We talked about equity. I mean, it's still available as a remedy in certain situations that aren't covered by the trust code. You just want to make sure that the remedy doesn't exist in the trust code. Things like declaratory judgments are equitable in nature. We've always taken those in equity to determine rights and trusts. Venue is another big subject. I know I don't have much time, but the rules of venue have essentially changed, and that has a lot to do with procedure on trying to get your case filed. I mean, we used to look at equity or still look at equity matters. The correct venue is the residence of the parties, any of the parties. Under the trust code now, venue is determined more by the principal place of business of the trustee. And there are some technical rules relating to that as well. If it's a testamentary trust issue, the place of venue will be in the court where the will creating the trust was allowed. If it's an inter vivos trust and there's a financial trustee, it's going to be the location of the financial trustee's business. If it's a personal trustee, it could be their residence. If there's co-trustees, it's a jump ball. So I think I'm probably going to end there because I don't want to step on any of Rob's.
Go ahead and step.
Yeah. But again, we just ask for a lot of patience, and I strongly recommend printing out the procedural advisory and the trust code itself. It's free, take advantage, and it's very well done. Thank you very much.
Next up is Rob Gray to talk to us about highlights for trustees and financial specialists.
All right. I have a couple of questions first. How many of you are currently serving as trustees? 1, 2, 3, 4, 5, 6, 7, 8, maybe about 10. I won't ask this question at the end of this little piece. How many of you think you would like to? What? For us. Or maybe there's 2. Okay. A couple of things is this little talk could be also described as something about the lessons from the School of Hard Knocks, but I'm going to try to stay on point and do the code. The committee report on the code with the code embossed in it, or included in it, is 54 pages long. It's really worthwhile reading. Now, the introduction to the code, one of the authors of it, who used to work for me until he got smart and went public and is not really in private practice anymore, he and his colleagues concluded that since most law schools don't teach as a required course, a course in fiduciary relationships or trusts, that they needed to do something to act as a guidepost for the rest of us poor fools who need some help in wandering through these very complicated areas. Massachusetts probably is the oldest, maybe Virginia's up there too. Those two states are the oldest two as far as developing common law. There's an awful lot that's not covered by the code, but it does help us a lot. And since it's not required in classes anymore, in law school, it's not a bad thing if you're involved with this, or you're a financial advisor, or you think part of your practice, whatever your business is, part of it's going to involve trust. It's probably a pretty good idea to look out for yourself and to look out for the people that you're advising, because some of them won't know about it. All right. The highlights I wanted to cover today are in a handout I gave you, and I'll go through those. They may trigger questions if there are some. I'll try my best to answer them. Section 103 talks about definitions. You want to review those with care. As an example, the word beneficiary has been modified to exclude holders of powers of appointment. You don't have to give notice to people if that's all they have, in most cases, if they're just the holder of a power of appointment. Another important one is a qualified beneficiary, because it helps determine which beneficiaries are entitled to notice as far as income beneficiary distributions or principal distributions. Now, earlier we had a little conversation about what kind of notice had to go to trustees if it was a pour-over trust, where there was a simple will that poured over the remainder to a now irrevocable trust created by the donor or the donor's spouse. Beneficiaries or trustees have a duty now under the code within 30 days from the time the trust becomes irrevocable to give notice to those beneficiaries. And 103 gives us some help as to who those are. I'll leave it to you to read them, but that's important. All right, 105. There are 10 rules that the code says have to be observed inside a trust. Beyond that, you've got a pretty reasonable free rein to write it the way you want to. Of the ones that I saw quickly, there are 5 that I consider to be really important. Maybe this is restating the obvious. The duty of a trustee to act in good faith. The power of the court to modify or terminate a trust cannot be written out of the document. The effect of a spendthrift provision. The court's power to adjust a trustee's compensation. The effect of any exculpatory clause. I want to spend a couple of minutes on trustees' compensation and exculpatory clauses as well. On trustees' compensation, many people are uncomfortable even talking about that unless it's in a formal situation where there is a bank or a professional trustee. If you are advising a professional trustee or a family member who's a trustee, they are entitled to be paid something. You want to have an open discussion about that fairly early on, and you want that disclosed in writing to the beneficiaries. Now, if you happen to be a lawyer and you're serving as a trustee, the Board of Bar Overseers has fairly interesting rules about this. You need to disclose your fees affirmatively, regardless of what the code says. You've got to tell the clients this, because you are acting as a lawyer / trustee, and those beneficiaries may also be clients of yours. You've got to give them that. It means you have to give them an engagement letter as a trustee / lawyer. Don't forget that.